Welcome to the Probate Nation. My name is Richard Ruddy, and I am the host of the show this evening. Our show this evening is part 2 of a 2-part program on obtaining guardianship of a special needs child. In prior shows, we have covered the importance of adults executing certain legal documents, such as durable powers of attorney and advanced health care directives, so that should you become incapacitated, someone is able to make legal and medical decisions for you. Good documents to have, and with them, your family very likely will be able to avoid the need to obtain a court-appointed guardian or conservator. But there is a group of children with special needs that cannot execute such documents when they become an adult at the age of 18. These often include children with autism, Down syndrome, dyslexia, and ADHD. Regardless of the nature of their special need, however, parents are faced with the need to obtain legal guardianship of their young adult child for a host of reasons, including medical decision-making, education decisions, and in time, housing and employment decisions. Absent such authority, the parents will be without the legal ability to manage all of this and more for the benefit of their adult special needs child. Our show tonight continues the discussion on the process that parents need to initiate and complete to be appointed the legal guardian of their adult child. We previously looked at the impact of turning 18 has on the ability of a parent to make those decisions for an adult child with special needs, as well as the petition to be filed to be appointed guardian and the rights of your child in this legal proceeding. Tonight we would look at the investigation and report of the guardian ad litem appointed by the court, the hearing itself, and what should be included in the court order entered by the court at that hearing. We will also touch on some common problems and pitfalls that often arise along the way. We are delighted to have back with us tonight the 2 elder law attorneys who began this discussion with us in the Part 1 show. Our first guest is a principal with the law firm of McCandless Lillard, with offices in Fairfax and Leesburg, Virginia. She's been practicing law for over 20 years and has extensive experience in the areas of guardianship, conservatorships, and special needs planning. She's a member of the Special Needs Alliance, an invitation-only group of disability and public benefits attorneys. She has been recognized as a top attorney by Super Lawyers and Washingtonian Magazine, and is ranked as one of the top 50 female lawyers in Virginia. Our second guest is a partner with the law firm of Dingman, Labowitz, PC in Alexandria, Virginia. He focuses his practice on guardianship, conservatorship, estate administration, and contested fiduciary matters. He also serves as a guardian ad litem for incapacitated adults. He has comprehensive litigation experience in state and federal courts, now primarily focused on elder law matters. He as well has been recognized as a top elder law attorney by Super Lawyers and Washingtonian Magazine since 2009. Please join me in welcoming back Attorney Liz Gray and Ken Labowitz. Guys, you're back.
Yes.
Thank you so much for coming back for this show. Well, there's a lot more to talk about as we complete this discussion about, a special needs child turning 18 and what we need to do to help them. So we're in the process, we talked about, we've filed the petition for guardianship. Mom and dad know there's 6 months to go before the child turns 18 and they want to get that process moving. We file our petition, and then the court appoints this person called a guardian ad litem. And of course, everyone says, well, I want to be the guardian. So tell me a little bit about the GAL. What's their role, and why are they involved here?
Well, the GAL is the basic investigator of the petition. The GAL is the eyes and the ears for the judge, so that the judge doesn't have to go out and meet this special needs person. So the GAL's job is to investigate the allegations in the petition, to serve the respondent or the special needs person with the petition, advise this person of his or her rights, including his or her right to an attorney and to attend the hearing, and to examine or cross-examine witnesses. And so that's what happens. We usually call that person the GAL instead of guardian ad litem.
Okay. So, well, that's important to know because people get confused by that. They see that person show up and say, what's going on here? So, Ken, what does the GAL actually investigate?
Well, supposedly, or theoretically, what's in the petition to make sure that there is an objective third person to come in and say, yes, I've spoken to the person who's the subject of this, and I've explained everything to that person, and I've asked questions. I've talked to the family. I've gotten a sense of what the individual thinks this should happen. And I know what some of the, again, theoretically, I should find out, does this person want to retain the right to drive? Does he want to retain the right to vote? Hunting, a guardianship order revokes the right to hunt, carry concealed weapons, run for office. There's I think, up to 40 different things that happen as a consequence of having a guardianship imposed, which is a nice way of saying that the individual's found to be incapacitated, as the legal term. And there are lots of things. We can tailor the order to match what the reality should be on the with the individual. But if you don't know, if you don't ask, you don't know. So
Sure. So for instance, if the child's got an individual education plan, we would reach out, and the GAL would reach out and talk to the school.
Perhaps. Schools are notoriously difficult to get any information from. That's a possibility. Frankly, from the standpoint of the lawyer, these are not particularly complicated cases. What should happen is what will happen in most cases. I can't think of a case in the hundreds that I've handled where an individual who needed a guardian didn't get one. Both for children, for those who are 18 and those who are older. I can think of a handful of instances when a guardianship did not come out, did not end up in an individual having a guardian appointed for him of whatever age. But the fights can be, and frequently the fight is, who should be in charge? Who should make the decisions? And the children of divorce, you can almost guarantee that there's going to be a fight over who should make the decisions, or under what circumstances should the parents work together. People who are not necessarily well able to work together given their own marital history. And you have outside, the grandparents may have different motivations or different attitudes than the parents. So that frequently it's not whether this person needs a guardian, but rather who should the guardian become. And in some cases, as Liz and I both know, sometimes it's not a family member at all. It should be some third person who isn't afflicted with all of the history that got us to this point in the first place. So.
Good to know. Now, Liz, the GAL gathers all this information. How do they communicate this to the court?
They're required to file a report with the court, and it tells the judge all of the information that Ken just went over about the whole situation. And it addresses a whole bunch of statutory requirements, jurisdiction, whether you think that the person with special needs should keep certain rights or not, those kinds of things.
Okay, and they communicate that to the court. Do they mail it to everybody who's supposed to get notice?
Anybody who is mentioned in the petition should be getting a copy of the GAL's report. By mail or email or however you're going to post service, but yes, you're required to make sure that everybody gets notice.
Okay. Well, we filed the petition, we've done the evaluation, the GALs submitted their report. Now we need to go to court. Okay, this is, is this a perimation moment, Ken?
Not really. These are generally about 90 some odd percent are uncontested. That is, it's not going to be the most difficult decision a judge makes on that particular day. There are some points of concern. In Virginia, anybody who is appointed as a guardian has to be present. You can't do this long distance. I know some places allow that. We don't. So. The scheduling is tricky because if the non-custodial parent or somebody else is coming in from out of town, you've got to make sure that that's convenient. And anytime you have more than two people involved, there's going to be somebody who's I'm not able to come this Friday, but what about next Friday?
Right.
So there's some jockeying about that. The court system is eager to have everybody heard. If you have something to let the judge know about, then you're welcome to come to court and say something. It doesn't happen often, but it certainly happens. It's not unique that if I want the judge to know that this child really wants to drive or really wants to vote, and you should come in and say that, and people do.
Well, I think that's something we want to really bring out when we talk about the court order as well. But how fast can we get the case heard?
Certainly in Northern Virginia, a couple of weeks is the norm.
Okay.
And If there's an emergency, there's a child who needs a decision made about surgery, for example, it can be done on an emergency basis.
Okay.
So there's no, certainly in Northern Virginia, there is a regular scheduled time, if not each week, every other week, when these cases will be heard.
Okay.
And it's just a function of the scheduling. You know, everybody needs to be there, so just you add in the petitioner, that is the parents who want to be appointed, the lawyer for them, and the guardian ad litem. That just takes some complication. It's worth noting that the person who does not have to be there is the person who's the subject of the guardianship petition. That person can be there, but is not required to be there. And for some kids, they certainly for the 18-year-olds, some of them like to come. They've seen courtrooms, and this is now their case. And some of them just don't want to be there. Right. So it is a decision to be made by the parents, I think, as to whether this would be more upsetting than it would be educational.
And most of these cases, would you say, are not contested?
Right.
By and large. Almost
not quite 100%, because there are some that can be argued about. Not to say that people will argue about anything, but there can be arguments about it. Primarily children of divorce, in my experience.
Yeah.
But anybody can come into court and say anything they want about this or any other case, frankly. So, but it's not generally the kind of thing you would see. It's not interesting enough to be on television.
Okay.
Do you tell your clients to plan on having their 18-year-old come to court?
I sometimes make suggestions not to bring the child to court. Just if it's not going to be useful for the child and disruptive for the child's life. Certainly, there are certainly 18-year-olds who need to have a regular schedule, and this is absolutely not. I hope there's no 18-year-old who makes a scheduled court appearance every week. That it may not be worth it for the child to come. So,
I've had a very interesting experience with a special needs child who actually was quite great communication skills. Mm-hmm. And I alerted in my report as GAL that be prepared, because she's going to ask some questions. And she got one of our Fairfax judges, and she was a little shy to start with, but then the judge knew that he needed to probe her, and then the Katie barred the door. She had a bunch of questions about why he became a judge and how do you like it,
really?
and was just and he loved it.
Right.
So,
and there are some judges who, I know one judge in Fairfax who has a special needs child, and he's into this. And there are others for whom it's just another day in the office. But uniformly, they are respectful, appropriate, want to hear what the parents have to say, and frequently compliment the parents for taking this on, because they're the logical ones to do it. There's nobody else out there waiting to do this, that's for sure.
Absolutely. But they're doing it because they love their child, and they're the best ones to do that. Well, we get to court, we've had the hearing, then the judge, we went to court to be appointed. Is a court order entered at the hearing?
Usually, yes.
Okay. So let's talk a little bit, Ken, about some of these, start with you, some of these issues, because the court order becomes the real document that we have to really carefully exercise our Scrivener skills in order to cover all these bases.
And one thing that television never talks about is that the judges make rulings, but they're really not official until there's a piece of paper that reflects what the judge has just decided. And when I started doing this, I can tell you that the orders were a paragraph, that so-and-so has been appointed to be guardian for the ward, signed by the judge. Now, I think mine is 8 typewritten pages. I'm not sure how long yours is these days.
7 or 8.
But we now put in lots of information just to avoid any problems. And the lawyers write the orders. The judges don't write the orders. Which one of us is appointed to make decisions? But the lawyers write the orders. And we now include things like that the guardians are the responsible parties for Social Security purposes, that they are allowed to get medical information under HIPAA, that they are, that for Social Security purposes, we put in lots and lots of information. Something I've had to learn how to do very specifically. If there's more than one guardian appointed, that each individual guardian is able to act independently of each other.
Very important.
I used to just think either of whom may act, but I've had pushback from various banks and doctors. Well, do you mean each of them can act independently of the other? Well, yeah, that's what it says, but I've had to add the language, either of whom may act independently of the other, just because it's not good enough. And I should say, I serve as guardian for a number of people. There is something mystic that's going on where we say we're the guardian and medical people immediately say, oh, you're the power of attorney. No, I said I was the guardian. And I've argued with medical people, a power of attorney to us as lawyers is a very different thing than a guardianship. But that's a waste of time. Trying to educate people who are convinced that guardians equal powers of attorney, don't bother. Just go with it. Go with the flow.
And I think it's important to stress that this show is about the guardianship approach and powers we're looking to empower the parent to have, so we can take care of the person and deal with the things that are non-financial. That's an entirely different thing. Well, let's kind of walk through some of the other things that we talk about here. So one of the orders going to do is there's going to be some finding that the child has incapacity.
That's correct. Okay, and for some people, that's really a mark of a negative, that they really argue, I don't want my child treated as incapacitated, because it really goes against the empowerment that we're advocating in this enlightened society. But that's the legal requirement. You have to be found to be incapacitated to have a guardian.
Okay, but with that said, the court wants the special needs person to try to be as independent as possible. And I always point that out to my clients, because it is, you try for 18 years to make sure your child is an adult and ready to go out into the world, and then all of a sudden you have to find that they're incapacitated and they're never going to be independent. I think it's tough for parents.
Yeah. But I think the big thing to remind people is that even though someone's appointed a guardian, that the guardian is encouraged to allow that person to participate and be involved in that to the extent that they can. And
let's be clear, if you're in a doctor's office and you're saying, I'm the guardian, I'm making decisions, the doctors are today, medical people generally, are trained to listen to the patient. So the fact that I have a piece of paper and here's this high-functioning, articulate individual who I happen to be guardian for, the doctor is not going to just close ears and, I can't hear you, I can't hear you. That's not the reality. And that's, sometimes I can say, I absolutely want to have this procedure done. And if the patient says, I don't want it, I don't want the flu vaccine, my signing a piece of paper saying, yes, give him the flu vaccine won't work. Doctors are not going to hold a patient down and inject them with anything. It's just not happening.
They're too sensitive to a whole bunch of issues there.
Right.
We talked about the big four powers. We certainly appoint the person, the petitioner, and then maybe appoint the standby guardians and get them named as the guardian and backup guardian. But we talk about the big four powers that are given to guardians. So you want to talk about those real quickly, Ken? Identify those?
Certainly.
Certainly we got the placing in Virginia facilities.
That's correct. So able to make medical decisions essentially through life and death. As guardian, I can withhold treatment and I can require treatment. I can authorize treatment. That's a little frightening, frankly. And it is as much power as any one person can get over another person in the legal system. And I'm not sure what you're referring to.
Well, the other thing we talk about interment and cremation, if they actually pass away, we have that particular thing. Now, we also talked about if we have joint guardians name, we want to be very careful about that language so that we can make sure they can act.
And what you don't want is a committee having everybody having to be in one place, particularly, again, with a non-custodial parent who's in Nebraska. That doesn't work if you have to have a committee. Any one of the guardians can act.
Okay. Now, Liz, typically the order will, if someone has, by chance, executed a power of attorney or advanced medical directive, will the order typically revoke that?
The order should revoke that. Okay. It's something that should be in the order, whether it's going to be revoked or not, but ordinarily it is revoked.
Okay. And how about the idea of bond?
People always ask about that. For guardianship, you only need a bond without surety, so it's really just on your honor. You don't actually have to pay anything for it.
So no insurance company gets involved. We talk about bond, but that's really kind of a personal personal bond.
Yep.
Okay.
And I assume you have the same experience I have, which is even though it says I'm bonding myself for $1,000 and I promise to do what I'm going to do, even people who don't do what they're supposed to do, I've never seen anybody have to forfeit the $1,000. So I'm not sure why we do that, but we do, because we always have.
It is part of that form. Well, let's talk about rights, Ken, that the minor child loses the right to do.
Right.
So a couple things. Contract?
Yes, and that's a good thing, because in the consumer society we live in, particularly with Amazon and everybody and anything else online, an 18-year-old can get himself into a lot of trouble. This was not with an 18-year-old, but I've had the experience where I got the daughter appointed guardian for her father, and the caretaker took him to the Toyota dealer and, using dad's credit, bought a new car. And eventually the daughter, as the guardian, gets the payment book from Toyota Motor Credit about, start making payments. And I had the pleasure of communicating with the people at Toyota saying, I'm sorry, but you all got hooked on this one. It's that he doesn't have capacity. He could not sign that contract. And good luck getting your car back, but we're not paying anymore. And Toyota wrote me a letter saying, you're right. So it's a very valuable tool for anybody, but certainly for an 18-year-old who has perhaps impulses to get nice things, and but isn't physically can sign a contract, can sign the paperwork or order from Amazon, but legally is not empowered to do so.
Okay.
The same with getting married.
Okay. Then there's several other things. I didn't want to run out of time here.
Right.
I wanted to also bring out. Let's talk about legal fees, because this whole process involving lawyers, lawyers like to be paid. They're doing things for a service a lot of times, but who pays for everybody here?
Well, usually the petitioners, the parents, pay the attorney's fees for filing the petition and getting them appointed. The guardian ad litem is set a fee by the court, and often with special needs children turning 18, they have no income and no assets, so they're going to be considered indigent. So when I'm acting as guardian ad litem for somebody indigent, I get paid $55 an hour out of court and $75 in court for my services as GAL in a guardianship.
And the state of Virginia pays for those fees.
And
It doesn't come out of the pocket of the parents who are already bearing a big load as it is, so that's a good thing.
It is a good thing.
Yes.
Well, let's jump ahead here, Ken. I know there's more things we could talk about from this order, but I don't want to run out of time. The order is entered, okay. Is the person now able to act as guardian?
There is a further step in the courthouse of going in front of a clerk and signing a bunch of papers and promising to do what you've just been appointed to do, including raising your hand to take an oath. What I like is that typically the clerk, the courtroom, the probate clerk asks, "Do you swear?" Well, sometimes, but
it's the only time you get to
yeah,
swear.
Exactly. So that you're formalizing this authority, but you then are given the badge, the certificate that shows, and that everybody seems to recognize as the evidence of your empowerment as the decision maker. And that's a good thing, to be able to have proof with a formalized court certificate that you really are empowered to act. And this, it's worth saying that this is unique among things that judges can order. This is not forever. If the individual improves and is able to act for themselves, we can undo it, and it happens regularly. It is quite remarkable to come back 10 years later and take it away, undo it. And we can modify it if the young person is able to get to the point of being able to drive. Well, we can come in and add that privilege back into the things that are available for the child, for the individual.
Okay, good. Now, I want to just touch real quickly, Liz, and we're going to go to the closing comments. Are there things that the parents should do in their own estate planning if they have the special needs child? Because even though they're a guardian, they're not, as we know, they're not going to live forever, and the child is much younger than them typically. So,
Almost always.
Almost always. What should they do in the way of special planning?
Well, they should do their estate plan, number one, and number two, they should include in there what we call a special needs trust, because you want that individual who is now 18 and an adult to qualify for certain public benefits, and there are limits on income and resources. So the way around that for the parents is to set up a special needs trust, which will have money available for this child at a time when they can't have access to the money.
Well, we really have literally run out of time, and this because there's been so much to talk about, and we covered some, but not all that we like to have covered.
Right.
How about some closing comments you'd like to share on this part of the program, brief as they may be, as we begin to wrap this up? Liz, how about start with you?
The voting is a big thing in Virginia for the judges I've found lately. And I've had a couple judges, when the GAL has said, I want to maintain their right to vote, has come back and said, no, I don't think so.
That it's contradictory to take away the capacity, to find an incapacity and then retain the right to vote.
Yeah.
How about yourself? Anything?
I think that someone like Liz, I am not an estate planner, but someone like Liz really needs to be involved sooner rather than later. We have made this so complicated with IRAs and KIOs and 401ks and thrift savings plans that there is just way too much going on. And if you don't do it right, you can dump thousands of dollars into the hands of a person who's not able to manage it. And that can easily be avoided, but it has to be planned.
Okay, good points. Guys, again, thank you so very much for coming back and sharing all this information for the great public service to the citizens of Northern Virginia. So thanks again.
Our pleasure.
You're welcome. Without a doubt, raising and caring for a special needs child is both challenging and rewarding. While you love your child dearly as they turn 18, certain legal steps need to be taken so that you have the legal authority to continue to make medical, educational, housing, employment, and other life decisions for them. In part one show of this topic, we touched on the challenges you can face as your special needs child becomes an adult, and the initial steps you need to take to start the process to become the court-appointed GAL for your guardian for your child. In part two show tonight, our guests reviewed the role, investigation, and report of the court-appointed guardian ad litem, what to expect at the hearing, and what should go into the court order entered by the judge. And they touched on some key estate planning you should consider to protect your special needs child in the years ahead. These two shows illustrate that this is a complicated undertaking with a number of moving parts. I encourage parents who need to initiate such a guardianship action to reach out to an attorney of their choice who is experienced in these matters. It will be time and money well spent. This brings us to the conclusion of our show today on Guardianship of Special Needs Child, Part 2. I hope you found both Part 1 and Part 2 informative. And remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.